Chief Justice of India D.Y. Chandrachud recently spoke at an event about the delicate balance between search and seizure powers and individual privacy rights in criminal justice. He emphasized the importance of maintaining this balance to ensure a fair and just society. He also highlighted the need for due process while acknowledging the necessity for law enforcement agencies to function effectively. Hello, I'm Shambhavi and you're watching LiveLaw. The event, the 20th D.P. Kohli Memorial Lecture, was organized by the Central Bureau of Investigation. The focus was on leveraging technology to advance criminal justice. During his speech, the Chief Justice referenced the PIL filed by the Foundation for Media Professionals regarding guidelines for seizing personal electronic devices. He mentioned the court's directive for agencies to adhere to the 2020 CBI Crime Manual on digital evidence until formal guidelines are established. The mentioned PIL was filed by 5 academicians seeking guidelines for the seizure of personal electronic devices by investigating agencies. The academicians have submitted a set of draft guidelines to this court. Let's understand some significant features of the draft guidelines. Number 1, seizure of electronic devices must take place only after a judicial warrant. Emergency seizure must be an exception with reasons recorded for not obtaining a judicial warrant. However, in either case, it is also required to be expressly set out as to why and in what capacity the device is required to be seized. Number 2, seizure should not be permitted on the ground that evidence may be found. They explained, and I quote, "In other words, seizure on the conjecture that evidence may be found will not be permissible in any circumstance, especially where the device does not belong to an accused person." Number 3, privileged, professional, journalistic or academic materials must be excluded from emergency seizure. The same will only be allowed by way of a judicial warrant and only if the material is directly linked with the crime. The petitioners explained, and I quote, "If the intention is to search such privileged, professional, journalistic or academic material, then it must only be by judicial warrant and upon the ground that the said material is directly part of the crime under investigation and not merely evidence of the same." This is the last order for the Supreme Court. This basically says that the Assistant Solicitor General mentioned that after looking at the current CBI and Karnataka cybercrime investigation manuals, as well as the suggestions from the petitioners, there have been several discussions. He said he would propose something within 6 weeks. In the meantime, he assured the court that all central government agencies will follow the CBI manual, at least for now. The CJI elaborated on the significance of the CBI manual, which mandates providing hash values for confiscated digital devices. Section 3, subsection 2 of the Information Technology Act 2000 explains the hash value. These hash values, which are similar to electronic fingerprints, are numeric values of a fixed length that uniquely identifies data and is used to represent large amounts of data as much smaller numeric. So they are used with digital signatures. These are generated under the Information Technology Act to safeguard the integrity of seized electronic devices. Additionally, the manual requires the creation of an image of seized electronic documents at the time of seizure, further safeguarding against tampering or manipulation. Furthermore, the CJI discussed new criminal laws aimed at digitizing various stages of a criminal investigation, from filing reports to delivering judgments. These laws, namely the Bharatiya Nagarik Suraksha Sahita 2023 and the Bharatiya Saksha Adhiniyam 2023, grant courts and law enforcement the authority to summon documents and materials, including digital evidence, for investigation. He explained that summons can now be issued electronically and testimonies from witnesses, experts, accused individuals and other parties may also be presented virtually. This innovation eliminates the need for physical documentation and enables swift communication between law enforcement agencies, courts and individuals involved in legal proceedings. The Chief Justice emphasized the importance of swift justice delivery, especially in CBI cases where the accused are charged with serious violations of the law, and how delays in case disposal can significantly affect the life and reputation of the accused. In terms of future improvements, he suggested the development of a mobile application with predefined timelines for different stages of investigation or trial. This app would serve as a platform for all stakeholders involved in a case, facilitating communication and coordination. Additionally, it should also alert parties and notify them of approaching deadlines. Mr. Chandrachud concluded his lecture by acknowledging the transformative reforms undergone by the CBI to strengthen its investigative capabilities. He highlighted the potential of advanced data analytics, cutting-edge forensic methodologies, and artificial intelligence to support crime detection, investigation, and prosecution. However, he stressed the importance of robust safeguards to protect individual rights and promote transparency, expressing confidence that a natively digital environment could significantly reduce case pendency and ensure citizen-centric justice. If you like this video, do not forget to like, share, and subscribe. Stay ahead with quick legal updates only on LiveLaw, and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month. Thank you.